Let's also introduce guests who are joining us on the broadcast. Zeenat Shaukat Ali, Islamic scholar; Subhash Jha, advocate; KV Dhananjay, Supreme Court advocate from Karnataka; Dr. Lubna Kamal, assistant professor from Jawaharlal Nehru as well, joining us on the broadcast. Dr. Lubna, how do you look at this verdict? This is an issue, very emotive one, that has divided the entire country. There are two extreme, views on it, and it looks like even the top court, the two judges, said they have divergent views on it, and it needs to be referred to a larger bench.
The question is to me?
Dr. Lubna, yes. Okay, we seem to be having technical difficulties. Let me ask Mr. Okay.
How much more time is...
Yes, Dr. Lubna.
Yeah, how much more time are we going to waste debating on this petty issue? Isn't this very extremely petty as regards to other issues we have on hand? The second thing is that, as clearly stated by one of the judges, what kind of law and order situation is this? Is this posing the girls' hijab? Is this posing any kind of threat to the government, to the national security? I mean, why is this such a big issue?
Well, Mr. KV Dhananjay, what's expected next? Let me ask Mr. KV Dhananjay, because in Karnataka as well, there's a section of students who are refusing to even go to these educational institutions unless they're allowed to wear hijab.
So that's true. By the way, this is a mere circular. And it's very unfortunate that courts spend weeks and months debating over the legality of a circular, which is not really what you would observe in many other Western democracies. So this being a mere circular, there is an election around the corner, and if for whatever reason this party loses power and some other party comes into power, it's just a matter of they replacing the headmaster or the principal who will in fact change the circular. So where are we going to stand? So this is not a statute, and it is very unfortunate that courts spend so much of time debating on the legality of a circular. The judgment, by lawmakers as to whether to ban a religious wearing as part of uniform has to be a legislative judgment. It has to come as part of a statute. That's not the case here. Now, this was I think the issue is so very complex in the sense that this is a matter that can have divergent issues. And I think this was all too expected. The Karnataka government is the one that made it look like, okay, on the issue of whether students must be permitted to wear hijab, there is judicial unanimity. And I think that was very dishonest, because you take smaller issues like in a civil suit when a defendant can be said to have been served. You could write an entire thick volume on what courts have said. Or you take another criminal issue like when...
that yes, this is an issue that is very tricky, it's very complex legally speaking, whether it's an essential practice in the religion, whether there's freedom to practice the religion, whether the reasonable restrictions on freedom of expression are valid or not. Those are all important questions of law. And let me take this across to Subhash Jha. Subhash Jha, is it really that simple? Dr. Lubna and KV Dhananjay would have us believe that we're wasting too much time on something that is a very simple issue that has very little in terms of legal sanctity or standing, given that it is just an order, and there is no statute, there is no law that is actually bringing out this particular aspect. How do you look at it, Subhash Jha? Are we really spending too much time, or are there really complex questions of law at hand here?
I'm in complete agreement with my learned friend, who appears to be a lawyer like me. I'm in complete agreement, and this is what was the argument which was advanced by me as well when I appeared for one of the parties opposing the petition. And I precisely said this. See, look at this problem. These problems are always created at regular intervals. This is not for the first time that the issue of hijab had fallen for consideration before any constitutional court. Way back in 2002, in Bombay High Court, the issue fell for consideration before a bench which was then headed by the Chief Justice, who became ultimately, later on, became the Chief Justice of India, Justice R.M. Lodha, and a bench of Justice D.B. Bhosle, who became the Chief Justice of Allahabad High Court. And they have repelled this kind of an argument that this is no religious practice at all. But I'm saying I've got something different to say. Way back in 2006, which would mean 16 years before, similar issue with regard to so-called right of a student, a male student then in that case, in Malaysia, which is a theocratic country, which is a Muslim-dominated country, where the Islam prevails. Look at what the Supreme Court of Malaysia had said way back in 2006. It's a reported judgment, and that too, it's a constitution bench judgment. That constitution bench judgment of Malaysia refers to about 4 decisions of our own Supreme Court on a particular issue, and then draws a parallel. There the student claim that I have a right to wear what is known as turban, or you must have seen in those Gulf countries, the sheikh wears a tire-like substance on their head. So that was the student claim that I have a right to wear that. The matter travels to the Constitution bench of Supreme Court, and the Supreme Court then said that we can't really do everything what Prophet Muhammad said, what Prophet Muhammad lived.
Right.
Now, for example, the Supreme Court gives an example that he lived in clay houses. He would brush his teeth with a twig of a plant. That means, are we going to be living the same lifestyle in which
Let me take that question. Let me take that across to Zeenat Shaukat Ali. Zeenat Shaukat Ali, number of points are being made by our petitioners, but the question is this, that if the judgment tomorrow goes against any one side, then the first question that will come up is that the court did not spend adequate time on it. But here we are debating that the court is perhaps spending too much time. So, either which way, it's a tricky situation. It's a catch-22.
I think, my very humble opinion is that the court is being extremely cautious, because there has been so much of hype around this, very, very non-hype. It should have been a non-hype issue, but there has been so much hype around it. But to my mind, what we are proceeding, I mean, whatever the judgment is, we have to respect it, and we have to honor what the courts are saying, and both the judges are thinking on completely different lines. But to my mind, I think, this entire secular understanding that we are promoting, that India is based on, and where in a school, the child would have become accustomed that, we are not cutting across, we are cutting across religions and cultures, and we are sitting together in a class as an Indian student studying a particular subject or studying on multiple subjects, and that, we eat together, we play games together, we study together, and that kind of a culture, I think, would have been a very major step, in my humble opinion, in taking the country forward. And, because this is not something, and this entire, concept that has been woven, that, the hijab cannot be worn, is going to be banned in the country. That is extremely wrong, because the Constitution permits a woman to dress the way she chooses to. So this was within an educational institution, where a certain idea of secularism, because and with the religious climate in the country at this point of time, I would have thought that, cutting across, whether it was a saffron robe or whether it was a scarf or whether it was anything, these things would have taken the students out into another spherical understanding of the Constitution also.
Right.
And this is my humble opinion. And those schools should not be attended on religious lines. Schools are not meant to, they are meant to teach you values, moral values, give you education, give you knowledge. That is the understanding of what an education institution represents. And I think that, clothing, decent clothing is part of that. So, and all in one clothing, all in kind of one dressing, to me would be important. Also, I would like to reiterate what I have been saying, that hijab is not an essential part of Islam, because the word hijab as used in the Quran 7 times is not to do with women's clothing.
Dr. Lubna, two important points there being made by Zeenat Shaukat Ali. It's come up during the hearing as well. A, that it's not an essential practice in Islam, and B, that it is ultimately for uniformity inside a school classroom, which is something that is perfectly acceptable, says Zeenat Shaukat Ali. Quickly, your response, please.
As far as her Islamic knowledge is concerned, I would like to ask for her credentials, her degrees in Islam. The second thing is that I completely agree. Uniformity in school uniform, I completely agree with that, and I would like to propose that uniform civil code should be implemented in schools as well, but then any kind of differentiation, any kind of be it kalawa, be it talaq, be it anything, be it hijab, everything should be abolished. Even the surnames, should be abolished, so that the students should be identified by their Aadhaar numbers or their maybe mobile numbers, so that then if the hijab is abolished, then it will be fine. But what happens in our schools, especially in government schools, I know better. So this just,
that's
keeping an
very
eye
radical,
on hijab.
madam. I don't think anyone has so far, even the proponents of Uniform Civil Code, nobody has proposed that surname should be banned inside the school. Yashwant Nigam also joining us on the panel. Mr. Nigam, how do you look at this judgment? It is a split verdict. Both sides, of course, saying that the Karnataka High Court judgment, of course, while it continues to stay in effect, each side now coming out to say that it is, a positive development as far as they are concerned, whereas it remains to be seen what view really the larger bench finally takes.
Yes, Madhav and Amita, let me point out one thing, that the High Court order will prevail as of now, because the status quo will be maintained. Now, secondly, it has to be referred to be a larger bench, and the larger bench finally take a decision. It could be 3 judges, it could be 5 judges. That is the discretion of the Chief Justice of India. Now, Justice Dhulia relied on the fact that it's a matter of choice, it's a right to education of a girl child. However, the one erroneous fact is that he has said the High Court should not have gone into whether hijab is an essential practice or not. However, this issue was argued by the pro-hijab lawyers in the court. It was not the court's creation. So that was clearly the stand taken by the pro-hijab petitioners who were there before the High Court, and therefore it was considered by the court and accordingly decided by the Karnataka High Court. However, on probably some kind of a legal advice in the Supreme Court, they took this as an alternative argument. Their main focus was that it is a part of their choice and that freedom is given as a fundamental right to them. However, then the question comes as an institutional right of the institutions, educations, colleges, schools, where there are certain rules, regulations, and that have to be followed. Now, if the tomorrow Constitution Bench decides...
There's a reaction coming in at the moment of BC Nagesh, who is in fact the Karnataka Education Minister. If we can cut across live to that.
That we are not ready to put hijab, we are not ready to put burqa. Everyone is supporting that. In this atmosphere, we had expected that totally the judgment of the Karnataka High Court would have been upheld. But there is a split verdict. We are not disappointed.
Are you hopeful now, sir? The matter has been referred to a larger bench. Are you hopeful that the verdict would come in the favor of what the High Court has said?
Definitely. Definitely I expect that the judgment of Karnataka High Court will be upheld in the higher bench.
And until such time, the hijab would remain banned and the High Court's order would continue?
Yeah, there is ban on hijab in the classrooms. Again, I am confirming. There will be totally no... Our student can put hijab and enter the classroom.
And this will hold for all religious symbols also, not just...
Yeah. Whatever the circular we had given earlier, that is valid. Thank you.
Well, in fact, that
reiterating
was
his point as far as the hijab ban is concerned, because the status quo still remains in place, what had been dictated by the Karnataka High Court in March this year. Let's get you more divergent point of views as well, as far as another Muslim cleric, Khalid Rashid, who has been batting for the hijab, saying that as per our fundamental rights and what's been enshrined in the Constitution, which clearly states that there is liberty to life and the women should be allowed to wear their hijab to practice their faith.
Islamic point of view is concerned, as per Islamic point of view, whatever Allah has stated in the Quran, and consider all those things as an essential part of our religion. So covering head has been ordered by Allah in Surah Ahzab and Surah An-Nur of the Quran. So it is mandatory and compulsory on the Muslim girls and women to cover their head. So as far as the Constitution of our country is concerned, you all know that Article 25 and then Article 21, which is related to the liberty of life and is considered to be the fundamental of the fundamental rights. So as per all these constitutions, constitution article also, the Muslim women and Muslim girls should be given the right to cover their head.
All right, let's take this across to our guests also joining us. In fact, Zeenat Shaukat Ali, I was asking you a question a little earlier in this bulletin to a retort that had come from Dr. Lubna earlier, saying that if you want to enforce uniformity, it has to be absolute. There should be no religious symbol, not even a surname should be allowed in the classroom. Are we taking things a bit too extreme here? Zeenat Shaukat Ali. Yeah, you made that point, ma'am. Now listen to the response. Ma'am, you made the point. Let's get in Zeenat Shaukat Ali, who you posed that question to.
I'm sure that she is a very great scholar. She knows more than the Imam Abdullah Mutlaq of Saudi Arabia. She knows more than Imam Tahtawi of Egypt and all the other countries that have ruled about regarding hijab, born in educational institutions or public offices, and the lines that they are going on. I'm sure she knows more than them, but I know less than them, so I go by that. And I go by the rulings that we are not the only country in the world practicing Islam. There are people all over the world practicing Islam, and where there are Muslim majority countries, certain rules have been adopted. You take Turkey, Tunisia, you take Azerbaijan, you take so many countries of the world, 57 almost Muslim countries of the world, out of which 3. Now, Iran is also revolting, and so is Afghanistan. So that is our case, a small part of Indonesia. So considering that there are people who are, ulama also, who are religious leaders also, who are talking about this, I think all these matters have to be considered overall.
Yes.
We are not the only people here who know it all.
Right.
But we know everything, and there is nobody below, above us. Everyone else is below us. Now that is something, a position that I am not willing to accept. Life is a learning process. The Quran is a book which is meant for all times. It is teaching you decency, but it is not teaching you this kind of uniform that you have adopted in the what you describe as a hijab. So now that is the point of argument that the court has to see, and this is my very humble point of view and perspective that I am giving you.
All right, before to Dr. Lubna. Dr. Lubna, 2 or 3 very important points. The ban on the hijab has been done as per the provision of secularism as far as the constitution is concerned. And earlier, we had Zeenat Shaukat Ali saying that by taking such a position, you're blinding yourself to the global jurisprudence. There are other Islamic countries which have done precisely the same.
Is this going to empower girls? Just tell me that. Thousands of girls have stopped going to school. So is it going to empower them?
Well, the reverse can also be argued.
Definitely not. The second thing is that I made that statement. I made that statement regarding the Aadhaar card number because I've seen students getting promoted and topping in classes based on their caste and religion. That is why I made that statement. And if there is going to be a ban on hijab, there should be a complete ban. That was one of my suggestions.
No, but that can also, I mean, there are multiple arguments that can be made. Deshrada Nigam, what do you make of this argument coming from Dr. Lubna? You know, that those divisions of caste, religion, etc. exist in society, and all of this should completely be removed from the classroom. You know, how much water does such an argument hold in the wake of what the bench itself has observed today?
In fact, if you look at the verdict of the High Court and what has transpired in the Supreme Court, it is very clear. Only 2 stands were taken by the pro-hijab lawyers. One was that it is an essential practice, which they diluted in the Supreme Court. And second is the fundamental rights that they enjoy, that right to freedom of expression and to choose. And therefore, once...
Sorry, I have to interrupt you. There's a reaction coming in from Karnataka. This is Priyank Kharge speaking. Let's listen.
ಹೇಳಿದ್ರಿ ಸರ್, ನಿಮ್ಮ ಪಾರ್ಟಿ ಒಂದು ಹೇಳಿತ್ತು ಏನಂದ್ರೆ ಈ ರಾಜ್ಯ ಸರ್ಕಾರ ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸವನ್ನು ಕರ್ಬ್ ಮಾಡೋ ಪ್ರಯತ್ನ ಮಾಡಿ.
ನೋಡಿ, ಯಾವುದೇ ಸರ್ಕಾರದ ಪ್ರಮುಖವಾದಂಥ ಜವಾಬ್ದಾರಿ ಏನು ಜವಾಬ್ದಾರಿ ಅವ್ರದ್ದು? ಮಕ್ಕಳ ಶಿಕ್ಷಣ ಕೊಡಬೇಕು, ಗುಣಮಟ್ಟವಾದಂಥ ಮತ್ತು ವೈಜ್ಞಾನಿಕ.
Cut right back to Priyank Kharge's reaction. Let's quickly go right back to our panelists. Yes, Deshrada Nigam.
You go on to fundamental rights, which was the basic thrust of argument in Supreme Court. It is very clear that there can be reasonable restrictions. This is well established by catena of judgments by various constitutional bench. And once reasonable restrictions come into the play, then you can upheld the ban on, hijab. Now, secondly, I believe it has not been argued before any court as to how the system of hijab developed. This has to go into the history, how it developed, because hijab concept developed because of the concept that women are sexual distraction and covering the body also. Now, this concept, this attitude absolves men of sexually harassing women and shifts the onus on the victim to protect herself by covering up. So this is the actual history of hijab. This is how the concept of hijab developed. This concept cannot be sustained in modern and progressive society. Right. And therefore, this is to be argued before the court as to the system and how it developed.
Right, but Deshad Nigam, and I'm going to take the question up to Mr. Jha as well. Mr. Jha, because the question that's being asked by Dr. Lubna, and at least one of the judges also ultimately asked that question, because the point under consideration for him was that how does this ultimately benefit the girl students?
You need to kindly fix your audio. What I'm trying to gauge from whatever I could hear, that you're asking me that how this is going to benefit the women, correct?
Right.
Hijab ban.
Yes.
Now, hijab ban, for example, I may tell you that there are 13 countries to which we could lay our hands to which have banned hijab. I may give the names: France, China, Denmark, Germany, Republic of Congo, Netherlands, and Belgium, Sri Lanka, Switzerland, Bulgaria, Austria, Norway, Sweden. All these countries have banned hijab. Now, hijab could possibly become a security threat. Let us not lose sight of that. And therefore, it is a question of public order as well. Now, I'm trying to tell you, give me 1 minute. I may only add to what Mr. Nigam has said, and rightly so, that this bench, the matter being referred to a bench of 2 judges itself possibly was a wrong decision. In my opinion, a matter of this importance, if it was so important, then it ought to have been placed before a bench of 3. But nevertheless, if it was placed before a bench of 2 judges, then they were bound by the decision of the earlier 3 bench judges rendered 6 years ago in the matter of Muhammad Jubair Corporal. He was an Air Force airman who sought intervention of the Supreme Court ultimately, that the government of India or the armed forces said that there is no question of growing beard irrespective of what religion you follow, except, of course, the Sikhs. The matter traveled to the Supreme Court and a bench of 3 judges, and incidentally, the judgment has been authored by Justice Chandrachud, who is going to be the next Chief Justice. And what does he say? It is necessity. There is a necessity to maintain uniformity among Air Force personnel, because of which his request had been rejected. So, request to grow beard was rejected by the armed forces. The matter travels to the Supreme Court, and the Supreme Court repelled this kind of an argument. I think the issue was set at rest then and there also. 20 years back,
but Mr. Jha,
the issue of hijab...
public order, sir. Mr. Nigam, if you want to add to that, because what really came out of the Karnataka High Court order also saying, as far as it also favored when it comes to speedy and effective investigation into the stoking up of the hijab controversy in Karnataka, and they were suspecting that there were some unseen hands at work that engineered social unrest and disharmony in the state. So you were talking about public disorder, public order rather, that has been also been questioned as far as the Karnataka High Court verdict is concerned.
Yes, Amita, in fact, if you read the Karnataka High Court, they said this is not a natural protest, it's an orchestrated, manufactured protest. And then we come to know that the Campus Front of India, which is a part of PFI, was involved and is stoking this unrest. So it was not a natural protest, not a demand by women. And finally, most of the women went into classes except 6 women. So therefore, this is a larger conspiracy, and the court said that you have to take strict action against such people. So therefore, public order was an issue. And secondly, now if you allow all kinds of symbols in classes, there will be chaos and disorder. You will not be able to control. So therefore, the discipline, public order within the classroom and within the school is also a question, apart from the public order in the larger society. So that issues have to be gone into very seriously. And the history of hijab, as I said, how it developed has to be gone into and its relevance in the modern progressive society and the rights of women. So therefore, one does not have to take a narrow view. Please understand the women have their own rights. But to say that you have a regressive right, I don't think the Constitution permits any regressive rights. It promotes only progressive rights. It clearly talks of equality between men and women, and that has to be upheld.